13th annual meeting and the 4th annual assembly. In 2016, we created the assembly to provide for a common experience that brings us together as a society during the annual meeting to conduct our elections and other business in the presence of our membership, to honor the achievements of our colleagues, and to commemorate those who have played an important part in the life of the society. The Assembly has been an exceptionally successful innovation, and we're pleased to continue this tradition in 2019. Before we begin the formal program, I want to take a moment to acknowledge our fantastic staff. Under the leadership of Executive Director Mark Agrast, they have spent many months meticulously organizing everything we experience at the annual meeting, as well as the many society programs, activities, and publications that you enjoy throughout the year. I'd like to particularly thank Deputy Executive Director Wes Rist, here to my right, who oversees every detail of this massive and complex undertaking and makes it all look so easy. Mark, Wes, and all the staff at Tiller House are talented, dedicated, and devoted to our society. And I hope that you'll take the opportunity when you see them in the hallways here to express your personal appreciation for the extraordinary work that they do. And I ask you all now to please stand so that you can join me in recognizing them. Thank you. We begin our program by calling to mind the leaders and members of the society whom we have lost since our last annual meeting. We will hear first from Professor Laurie Damrosch of Columbia Law School, a past president of the society, who will offer brief remarks in memory of Ambassador Richard N. Gardiner. We're also honored that Ambassador Gardiner's daughter, Nina Gardiner, is with us here today.
Thank you, Sean. Richard Gardiner occupies a unique place in the history of United States diplomacy, in the teaching and practice of international law, in scholarship across a wide range of fields of interest to our discipline, and in the life of this society. He was my valued colleague and mentor at Columbia University for many years, not just at the law school, but also at the School of International and Public Affairs, where he nurtured and inspired generations of diplomats and policy experts to follow the call of public service. Having ascended the academic ladder to ever more dazzling heights, from Harvard BA to Yale JD 1951 to Oxford Rhodes Scholar and DPhil 1954, he began teaching international law at Columbia and remained there for 6 decades through and beyond his retirement from teaching in 2012. At Columbia, he was the Henry L. Moses Professor of Law and International Organization, and he taught international law and a legendary seminar, Legal Aspects of U.S. Foreign Economic Policy. For today's tribute, I would like to focus in particular on his contributions to this society. The proceedings record that he attended his first annual meeting in 1951. He gave his first banquet speech in 1965 on the same program as then Secretary of State Dean Rusk. He served in our leadership as a vice president from 1973 to 1975 and addressed our annual meeting on multiple occasions. One time I remember in particular has special resonance for the current period. He gave the banquet address in 1996 at the invitation of then President Edith Brown Weiss. It had the memorable title, "Who Needs Ambassadors? Challenges to American Diplomacy Today." Based on his 2 4-year terms as President Carter's ambassador to Italy And then as President Clinton's ambassador to Spain, he illuminated the need for a fully funded US presence in all countries where the United States has diplomatic and consular relations for a robust pursuit of both bilateral and multilateral diplomacy. Prior to his ambassadorial service, Dick held the position of Deputy Assistant Secretary of State for International Organization Affairs in the Kennedy and Johnson administration. He played a role in international legal diplomacy during the Cuban Missile Crisis, as he would frequently recall in the classroom. He drew on the legal lessons of the Cuban Missile Crisis for significant contributions to society-sponsored publications on the use of force, which I commend to the attention of anyone in this audience who would like to reflect on the lessons of the Cuban Missile Crisis for contemporary policy challenges. For example, is there a valid argument for anticipatory self-defense against a state like Iraq between 1991 and 2003, or North Korea or Iran more recently, on the basis of apprehensions that the state in question has or might have weapons of mass destruction or a program to acquire them? Relying on his insights from the Cuban Missile Crisis, Dick argued that the so-called Bush doctrine of preemptive self-defense, as advanced by proponents of military intervention in Iraq in 2003, would open too wide a loophole in the prohibition on the use of force. The considerations, and I'm quoting here from his article in the American Journal of International Law published in the Agora in 2003 on the future implications of the Iraq conflict. He wrote, quote, "The considerations that led us to avoid enlarging the concept of preemptive self-defense in 1962 are just as valid today." And the citation is 97, AJIL at page 588, but then he goes on at page 590 to make some modest, what he called modest proposals for modest reinterpretation of the charter to meet the legitimate needs for use of force in appropriate circumstances. In April of 2012, we held a festive and substantive celebration of his 6 decades of teaching and public service at Columbia. The proceeds were published in 2012 by the Columbia Journal of Transnational Law in a special issue of almost 200 pages under the title, "The Challenges We Face," a conference honoring Professor Richard Gardiner's retirement from teaching. I know a number of members of this society who are present today participated in that happy occasion where Dick reveled in the company of his old friends, including Stephen Schwebel, Zbigniew Brzezinski, Paul Volcker, Michael Doyle, and many of his former students, including our president, Sean Murphy, and Dick's very own, very brilliant children, Nina and Tony Gardiner, both of whom went on to distinguished careers in international law and international relations. We will honor Dick's memory at Columbia on October 6th, 2019, and his many friends and admirers in this society are all cordially invited to join us on that occasion. Thank you.
At this point in the program, we had intended to have Professor Jenny Martinez say a tribute to Judge Pat Wald, but unfortunately the Beltway traffic has not cooperated with Jenny Martinez's presence, so we'll hold that to a little bit later in the program. Instead, I'd now like to ask our honorary president, Professor Michael Reisman of Yale Law School, to offer brief remarks in memory of Professor Prosper Weil. We're also honored that the family of Professor Weil is represented here today by his granddaughter, Society member Daphne Richmond Barak.
Thank you, Sean. In 2001, the Society awarded Prosper Weil the Hudson Medal for his achievements in service to international law. Prosper was born into an observant Jewish family and grew up in a small village near Strasbourg. The war broke out 3 weeks after he celebrated his bar mitzvah, and in July 1940, Prosper and his family were expelled, along with most Alsatian Jews, to the Vichy-administered Free Zone. His family settled in Nice, where by mere chance they managed to evade the many roundups of Jews until the defeat of the Nazis and the liberation by the US Army in August 1944. I draw attention to Prosper's origins because being a Jew and observant was an important pillar of his life, and though private, I think he would have wished to have it noted, especially now. One of the 3 courses he delivered at the Hague Academy was entitled Judaism and the Development of International Law. Prosper commenced his career in administrative law, where he quickly won renown. He began to veer toward international law in the early 1960s with a course of lectures on international administrative law. But long after he himself had turned to and distinguished himself in international law, his administrative law scholarship continued to be authoritative in France and Francophone countries. He was named Professor of International Law at Paris II in 1965 and also served as the director, then Honorary Director of the Institute of Higher International Studies in Paris. He was a member of the Institut de Droit International and was elected to the Académie des Sciences Morales et Politiques, filling the chair left vacant by the death of René Jean Dupuy. Prosper was involved as counsel or arbitrator in many of the great cases of his generation, among them Manquier and Acrejo, Rainbow Warrior, Barcelona Traction, Beagle Channel, Qatar and Bahrain, and Fisheries Jurisdiction. He was a member of the Administrative Tribunal of the World Bank and presided over it from 1989 to 1993. He was a frequent arbitrator in international investment arbitrations. A man of principle, he did not hesitate to dissent, and his reading of his dissents is always rewarding. Even in the celebrated case of Tokyo Sokelis, where he served as chairman, he dissented from the decision on jurisdiction and resigned. In addition to his law of maritime delimitation, a collection of his essays, American international lawyers know Prosper's work largely through his seminal essay in the American Journal of International Law, entitled Towards Relative Normativity in International Law, which was elaborated in his general course at The Hague under the title International Law in Quest of Its Identity. Both of these pieces reflect his analytical precision and register his disquiet over the proliferation of types and levels of normativity in contemporary international law. His critique of this development stirred controversy, though it is now taken for granted that an inescapable part of the task of the contemporary international lawyer is to identify, for each problem and each situation, the applicable and effective law. In rereading Prosper's analyses, one encounters a jurist in torment over this recurring challenge. We find ourselves, he wrote, adrift in ever-widening circles of increasing uncertainty. Yet, ever the scientist, Prosper acknowledged that what he called pre-normative acts, and I quote his words now, do create expectations and exert on the conduct of states an influence that in certain cases may be greater than that of rules of treaty or customary international law, end quote. I had the privilege of knowing Prosper and his wife Viviane. Working with him on a case before the court, I saw how much Vivian, a lawyer and his former classmate, contributed to Prosper's work. They were, in fact, a two-person law firm, as Daphne Richman Barak, Prosper's granddaughter, described it. As a person, Prosper was courteous, dignified, and modest, never retreating on a matter of principle, but never pushing it to the point of being cantankerous. In a eulogy, Alain Pellet, the president of our French Colleague Society, described Prosper with Gallic precision: a great scientist, a great gentleman, a good man. That says it all.
Although time does not permit us to offer spoken tributes to all those whom we remember at this time, their names will appear now on the screen and are also in your programs. And I invite you to rise while I read them aloud. Kofi Annan, James G. Apple, John Merrills, Yasuki Onuma, Mohammed Shahabuddin, Mark N. Sills. Please join me in a moment of silence as we remember them all. Thank you. Please be seated. I rarely get to use this gavel, but I'm told I'm allowed to use it at this moment. I'd now call to order the annual general meeting of the Society. So our first order of business is recognition of the outgoing officers and members of the Executive Council, and I want to thank them for their service and dedication, and to express my personal appreciation to them for their good counsel and fellowship. I ask the outgoing officers and Executive Council members to please rise so that you can be recognized. I'd like now to acknowledge the work of our 2019 annual meeting co-chairs and their committee in planning this magnificent annual meeting. With the co-chairs Rebecca Ingber, Neha Jain, and Rahim Malou, and all of the members of the annual meeting committee, please rise to be recognized. It's now my pleasure to announce the co-chairs of the 2020 annual meeting. Adejake Babington Ashahe of the World Bank Administrative Tribunal, Ruchi Gill of Covington and Burling, and Jared Wong of the University of the Pacific McGeorge School of Law. I'd like to ask Jake, Ruchi, and Jared to please rise and be recognized for the work you're about to do. We'll now proceed to the election of the new officers, Executive Council members, and counselors for 2019. First, I'd like to acknowledge the members of this past year's nominating committee for their diligent and thoughtful work in assembling the slate of nominees that are now before us. Immediate past president, Lucinda Lowe, chaired the committee, which included Monica Hakimi, Melida Hodgson, Louis Yamzone, Stephen Mathias, and Bess Van Schok. Would the members of the committee who are present please rise to be recognized? Pursuant to the Society's constitution and regulations and the nominating committee guidelines, the nominating committee submitted a slate of candidates for all elective offices at least 90 days in advance of this general meeting. And notice was provided to members of the Society at least 60 days in advance of this meeting. The names of the nominees appear in your program and are now on the screen. He paused to see the screen change. All applicable requirements having been met, is there a motion for the slate to be approved? Is there a second? All in favor, please say aye. All opposed? I think the ayes have it. The slate is approved. I ask the new officers, council members, and councilors to stand so that you can join me in recognizing them. Pursuant to the Constitution and regulations of the Society, the following members have been nominated to serve on the 2019-2020 nominating committee. Natalie Reed as chair, Tendai Achiomi, Jose Alvarez, Whitney Debevoise, Monica Hakimi, and as alternate, Chiara Giorgetti. Is there a motion for this slate to be approved? Is there a second? All in favor, please say aye. All opposed? Again, the ayes appear to have it. The slate is approved, and I ask the members of the new nominating committee to rise to be recognized. Before we conclude the annual general meeting portion of our assembly, it's been our custom to ask whether there is any other business to be brought before the meeting. So, is there any other business? Seeing none, I declare that the annual general meeting is now adjourned. Do I get to do this again? So we turn now to the presentation of honors and awards. First, we will recognize our new emeritus members. Emeritus members are those who have been members of the Society for at least 50 years and are entitled to all the privileges of membership without further payment of dues. This year, we recognize 11 members who have attained that exalted status. This is truly an illustrious list. It includes some of our most cherished members. I ask those who are present to rise at their seats as I read their names, and then please hold your applause until we get to the end. Shigehiko Goto, Gunter Handel, Gary Horlick, Cecil Hunt, Peter Newman, Uffe Rasmussen, David Ruzi, Ivan Shearer, Donald Sorochen, Robert Spurl, David Stewart. Congratulations. I turn now to the announcement of the 2019 Helton Fellowships. The Helton Fellowship program was established in 2004 to recognize the legacy of Arthur C. Helton, our colleague and friend who died in the bombing of the UN mission in Baghdad in 2003. I'd like to acknowledge the support of Arthur's wife, Jacqueline Gilbert, and our patrons, Ben and Don Ferenz, whose generosity has done so much to sustain these fellowships. I'll now announce the 5 Helton Fellows for 2019, and again, please hold your applause until the names have been read. Abby Keegan-Buttle, Catherine Cohen, Haley Evans, Asavri Rai, Radhika Saxena. Please join me in congratulating the new Helton Fellows. I now turn to the prizes that have been awarded by interest groups within the Society. I invite each winner to rise to receive your applause as your name is announced. The International Refugee Law Interest Group has selected Amelia Trulock as the winner of the student writing competition for her submission entitled Colonizing Queerness, Determining LGBT Credibility in the UK Asylum System. I'll now announce the recipients of the awards presented this year by the Liebherr Society on the Law of Armed Conflict. The Francis Liebherr Prize in the article category is awarded to Polina Levina Mahnad for her article entitled Protecting Cultural Property in Syria, New Opportunities for States to Enhance Compliance with International Law. The Francis Liebherr Prize in the book category is awarded to Ruba Al-Salam for her book entitled Security, Rights, and Law, the Israeli High Court of Justice and Israeli Settlements in the Occupied West Bank. The Liebherr Society's 2019 honorable mention for the Richard R. Baxter Military Prize is awarded to Major Trent Powell, Lieutenant Colonel Shane Reeves, and Colonel David Wallace for their article entitled Revisiting Belligerent Reprisals in the Age of Cyber. And finally, the Liebherr Society's 2019 Richard R. Baxter Military Prize is awarded to U.S. Army Captain John Thomas Bennett for his article entitled Reaping the Whirlwind, the Norm of Reciprocity and the Law of Aerial Bombardment during World War II. Please join me in congratulating the winners of the Liebherr Society prizes. The last of our interest group prizes is the 2019 Prominent Woman in International Law Award, which will be presented by the Women in International Law Interest Group at tomorrow's Willig Luncheon. That award will be presented to Professor Tracy Robinson. Please join me in congratulating her. Last year's annual meeting was dedicated to the memory of former ASIL President David D. Caron. In the months that followed, the Society established the David D. Caron Fund to pay tribute to his life and achievements and to perpetuate his legacy. The fund will be used to support the Society's research forum, which was created by David during his presidency. In particular, the fund will support the David D. Caron Prize, awarded to the best paper presented at the research forum by a current student or recent graduate. The fund also will support the awarding each year of David D. Caron Fellowships, which will help defray the travel expenses of students or recent graduates who have been selected to present a paper at the research forum, but who require financial assistance to attend. During our mid-year meeting at UCLA Law School this past November, we held a convocation marking the formal establishment of the fund. And with us on that occasion was David's wife, Susan Spencer, who announced at that time the winner of the inaugural prize. Today, Susan is here with us again to formally present that prize to the winner. And so I'd like to invite Susan Spencer and ASIL's Executive Director, Mark Agrast, to come to the stage with me now to present the first David D. Caron Prize. While they're coming to the stage, I'd like to acknowledge the 185 donors who have contributed to the David D. Caron Fund. In particular, I'd like to express my deep thanks to Judge Charles Brower and to the Caron and Spencer families for their generous matching gifts, and to Dr. Kian Murphy, who worked tirelessly with us to bring this initiative to fruition. And I'm particularly pleased to report that as of just this week, we have surpassed the $300,000 mark for the David D. Caron Fund. And now I'm very pleased to announce at this assembly the winner of the first David D. Caron Prize, Leon Castellanos Jankowicz of the Asser Institute Center for International and European Law, for his paper presented at the 2018 Research Forum entitled Nationalism and Early International Rights. I note that by coincidence, I was assigned to moderate the panel at the Research Forum at which Leon presented his paper. And at that time that I was appointed to moderate, we didn't know he would get the prize, but it was quite the coincidence and quite a pleasure to see Leon present and ably defend his panel. And I'm very delighted that Susan is here to assist me in presenting Leon with the very first David D. Caron Prize. I now turn to the presentation of our certificates of merit. Before doing so, I'd like to thank the 2018-2019 Book Awards Committee for their outstanding work in selecting this year's award recipients. The committee was chaired by Anna Spain Bradley, with committee members Karen Alter, David Gantz, Christina Herreras, and Michael Reisman. I'd like to ask Anna to join Mark Agrast and me on the stage to present the certificates. As Anna comes to the stage, please join me in recognizing the outstanding work of her committee. This year's committee awarded 2 honorable mentions in addition to the 3 certificates of merit. As I call out your names, I invite the recipients to join us up here on the stage to accept their certificates. The honorable mention in a specialized area of international law is awarded to Orna Ben Naftali, Michael Svard, and Hedy Viterbo for their book entitled The ABC of the OPT, published by Cambridge University Press. We're pleased that Professor Ben Naftali is here to accept the certificates on behalf of all 3 authors. The honorable mention for high technical craftsmanship and utility to practicing lawyers and scholars is awarded to C. Donald Johnson for his book, The Wealth of a Nation, published by Oxford University Press. Please join me in congratulating Ambassador Johnson. We now turn to the presentation of the 3 certificates of merit. The Certificate of Merit is in a specialized area of international law, is awarded to Maureen Tehan, Lee Godden, Margaret Young, and Kirsty Gover for their book entitled The Impact of Climate Change Mitigation on Indigenous and Forest Communities, published by Cambridge University Press. I think we're pleased to have Maureen, Lee, and Kirsty here, and Margaret Young could not make it, but Finola O'Sullivan of Cambridge University Press will accept the certificate on her behalf. Please join me in congratulating you. It's quite the operation here, isn't it? The Certificate for High Technical Craftsmanship and Utility to Practicing Lawyers and Scholars is awarded to Dame Rosalind Higgins, Philippa Webb, Dapo Akande, Sandesh Sivakumaran, and James Sloan for their compendium entitled Oppenheim's International Law, United Nations, Volumes 1 and 2, published by Oxford University Press. We're pleased to have, I think, 4 of the 5 authors with us to accept the award, and I welcome them to come to the stage. Unfortunately, Sandesh could not join us, but John Louth of Oxford University Press will receive the certificate in his absence. Please join me in congratulating all of these authors. See if we can all fit. Thanks so much. The Certificate of Merit for Preeminent Contribution to Creative Scholarship is awarded to Craig Forsees for his book entitled Destroying the Caroline, the Frontier Raid that Reshaped the Right to War, published by Irwin Law, Inc. Please join me in welcoming Craig to the stage to accept his award. We now come to the point in the program when we confer the honors of the Society. But before we do that, all presidents know to listen to what's being said behind them. We are going to return to that part of the program where we were commemorating those that we've lost over this past year. And I'm going to ask now Professor Jenny Martinez, recently named as the Dean of Stanford Law School, to join me on the stage to give brief remarks in memory of Judge Patricia McGowan Wald. We welcome Harry Stark, Pat's grandson, who was able to join us this evening.
Thank you, and my sincere apologies for insane traffic delays from Dulles that delayed my arrival. It's my privilege to offer this memorial tribute to Judge Patricia Wald, a friend of the American Society of International Law and a champion of international justice, and for whom I had the privilege of clerking at the International Criminal Tribunal for the former Yugoslavia. When Judge Wald passed away this January at age 90, our world lost one of the world's greatest judicial minds of the century. As President Barack Obama said in awarding Judge Wald the Presidential Medal of Freedom, Pat Wald made history as the first woman appointed to the DC Circuit. Rising to chief judge of that court, she always strove to better understand the law and fairly apply it. After leaving federal service from the DC Circuit, Judge Wald did not go into retirement, but instead moved to The Hague to support the work of international justice. During the 1990s, she'd been extremely active in promoting rule of law efforts in Eastern Europe with the American Bar Association. And so when the opportunity came to serve on the International Criminal Tribunal for the former Yugoslavia, she jumped to taking it. There at the International Criminal Tribunal, she did important and path-breaking work, as I will talk about in a moment. Returning to President Obama's description of her, she said, she was hailed as a model judge and she laid a foundation for countless women in the legal profession and helped unveil the humanity within the law. Her ability to unveil the humanity within the law was no doubt a product of her extraordinary life. She was born to a single mother, grew up at a time when women were not expected to go to law school, and was one of only 10 or 11 women in her law school class of 1951 at Yale Law School. After that, she clerked and then left the workforce for some 10 years to raise her extraordinary 5 children. Upon returning, she served as Assistant Attorney General for Legislative Affairs during much of the Carter administration, again as the first woman to hold this position before being appointed to the DC Circuit. During her time on the DC Circuit, she authored more than 800 opinions on every issue of federal law, with particularly notable opinions in administrative law, freedom of information, executive privilege, constitutional rights, and gender equality. Especially important for this audience, she wrote a dissent in the case of Prince versus Germany, a Foreign Sovereign Immunity Act case involving slave labor claims against the German government related to the Nazi regime. In that opinion, she was in dissent in arguing that Germany's violation of Jus Cogens rights in the operation of slave labor and other crimes committed during the Holocaust constituted a waiver of sovereign immunity, arguing that Germany should have had no reason to think that it could not be held accountable for the terrible crimes that were being committed. On the ICTY, she issued landmark judgments, including the Kirstich decision, the first genocide conviction coming from the ICTY related to the Srebrenica massacre, which made important jurisprudential developments and forsaged the more recent convictions of Karadzic and Mladic, forming some of the most important work of that tribunal. She also issued a dissent in the Kupreskic case, in which not as a dissent, she wrote the appeals chamber judgment in the Kupreskic case, in which the court overturned convictions by the trial chamber, saying the goal of expediency can never be allowed to override the fundamental rights of the accused to a fair trial. After leaving the ICTY, she continued an important government service, serving on the President's Commission on U.S. Intelligence Capabilities regarding weapons of mass destruction and the Privacy and Civil Liberties Oversight Board. To use her own words, she said, in describing her view of the law, I see the law as a way to translate our most fundamental aspirations and goals for an open and orderly society that treats all people in the community with respect, and as a vehicle in which to move our society and everyone in it to a better place. Doesn't always work out that way in the short run, but I never stop trying. In that, may she be an inspiration to us all. Thank you.
Thank you, Dean Martinez. It was wonderful to have you here. We now will turn to the conferring of the honors of the Society. These honors recognize distinguished individuals whose lives and achievements exemplify the highest ideals of the Society. First, I'd like to express my appreciation to the 2018-2019 Honors Committee for their excellent work in selecting this year's honorees. The committee was chaired by Jeff Dunoff, with committee members Marcella David, Harold Coe, Judge Margaret McEwen, and Sergio Puig. As Jeff joins Mark and I here on the stage, please join me in recognizing the excellent work of Jeff's committee. The Society's highest honor, the Manley O. Hudson Medal, has been awarded since 1959 to a distinguished person of American or other nationality for outstanding contributions to scholarship and achievement in international law. Earlier today, we presented the medal at the Hudson Medal Luncheon to Associate Justice Stephen G. Breyer of the Supreme Court of the United States. Please join me in congratulating Justice Breyer. Next, the Golar T. Butcher Medal has been awarded since 1997 to a distinguished person of American or other nationality for outstanding contributions to the development or effective realization of international human rights. We're deeply honored to present the 2019 Golar T. Butcher Medal to the former UN High Commissioner for Human Rights, Zaid Ra'ad Al Hussein, who I now welcome to the stage to accept the award. Congratulations. It's a pleasure. Finally, the Society's Honorary Member Award was first presented in 1906. It recognizes an individual of American or other nationality who has rendered distinguished contributions or service in the field of international law. We're deeply honored to present this year's Honorary Member Award to Monica Pinto, who I invite to now come to the stage. Very good. I'm delighted that Monica has agreed to be our keynote speaker for this assembly, so I'm not quite letting her leave the room. By way of introduction, though, let me say that Monica recently completed her term as dean at the University of Buenos Aires Law School, where she teaches and has written extensively on international law and international human rights law. She's held a number of positions in the UN system, including as Special Rapporteur on the independence of judges and lawyers, and as an independent expert on the human rights situations in Chad and Guatemala. She has served on the Advisory Committee on Nominations for the International Criminal Court and sits on the administrative tribunals of the World Bank and Inter-American Development Bank. A longtime member and active supporter of our society, Monica has been recognized with numerous international honors for her work in international law and human rights. So please join me in welcoming Monica Pinto as our keynote speaker on the topic, International Law as an Instrument Dialogues, Tensions, and Accomplishments.
Thank you, Dan. Good evening to everybody. Many thanks to the Society for this invitation. I really feel honored. My purpose in these minutes is to stress some of the profound changes underwent by international law in the last 40, 50 years, and to illustrate for you how international law was a useful instrument to shape them. A good reason for us to keep working in this field. Imagine this picture. By the mid-50s, there was a man who became president of his country as a result of a military coup. He put the constitution between brackets, he imposed censorship, practiced torture, as well as arbitrary detentions and summary executions. The number of victims of his regime amounted to almost 20,000 people. He was ousted from government by a revolution and exiled in another country whose record was not much better than his. He died while doing business in a third country, which was also under dictatorship. Had these facts taken place recently, the story behind the picture would have been quite different. Democratic states find coup d'etat inadmissible. There is increasing condemnation, and some procedures have been dealt with in order to treat this situation, as it happens in Europe and in the Americas. This man's government would have had to deal with lots of complaints regarding human rights violations. Once out of office, an inquiry commission would have been set up to shed light on the facts, and very probably himself and others would have been brought to trial in the local judiciary or an international criminal tribunal. Victims should have been awarded reparations. This example reveals some of the ways in which international law has been an instrument for different international actors, as well as its incredible enlargement in the field of objects, of those themes that are relevant for international law. These phenomena are growing and make room for dialogues, tensions, accomplishments, and failures. More than once, the same situation involves nearly all of them. I intend to show first that dialogues have been mostly fruitful. Secondly, that tensions are inevitable situations that arise when new institutions or rules are tested against policies or behaviors which are closer to the horizontal Westphalian model than to the institutional pattern of San Francisco. Lastly, I will deal with the accomplishments, those cases in which international law succeeded in areas in which neither their main actors nor ourselves, the citizens of the world, would have ever dreamed of having a successful legal answer at the international level. Dialogues are easier between neighbors, those who share something. What we call regionalism in international law expresses the same idea. Commonalities help to find ways to raise legal thresholds and to ensure a better legal protection. In this sense, the legal and political order established after the Second World War envisaged regional organizations to improve the possibilities of a peaceful settlement of disputes. Other regional projects also took shape, the protection of human rights and also economic cooperation and integration. They all played in the same scenario. However, they did not get together easily. The evolving importance of the regional human rights systems soon put them in dialogue with the respective regional political instances, and the product of such dialogues has been generally highly rewarding. In 1950, shortly after the Rome Convention on Human Rights had been adopted, the European communities came into being. Strasbourg and Luxembourg started working in parallel. As the communities evolved, the idea that they had to consider some degree of human rights increased. In 1970, in the case Internationale Handelsgesellschaft, the European Court of Justice decided that fundamental rights did form an integral part of the general principles of community law, and that inconsistency with fundamental rights could constitute the basis of a successful challenge to a European law. A close dialogue started then, which led, many years after that, to the adoption of the Charter of the Fundamental Rights of the European Union. EU member states remain bound by the Rome Convention, and they are still accountable in front of the Strasbourg Court of Human Rights. But as the Charter of Fundamental Rights has enshrined some political, economic, and social rights of the Union citizens and residents into EU law, Strasbourg and Luxembourg had to learn how to work complementarily. Notwithstanding its success, the dialogue in this case was not exempted from tensions, as when, for instance, the Cady case arose. The anti-terrorist measures adopted by the Security Council, enforced within the EU and the fundamental rights of the Union, clashed. And suddenly, the dilemma was whether to accept blindly the disposition on the freezing of actives under the suspicion of being used for the financing of terrorism, or the respect of due process of law and the right to property. The European Court of Justice insisted on the EU position of compliance towards the United Nations Security Council decisions in the field of the struggle against terrorism, but with a caveat in the sense that, being a domestic matter within the EU, fundamental rights have to be observed. And that was the case for the right to defense and the right to property alleged by Mr. Cady. Criticism arose because of a so-called dualist approach of the Luxembourg court. It may be like that. However, the decision gave rise to a revision of the system, which, at the end of the day, reduced the divergences between EU and UN law. African institutions have also been sensitive to dialogue. The African Commission on Human and People's Rights was the first body in the region for this matter, and it became truly busy. Once the African Court was established, the takeoff was slow. Certain human rights found their way through the analysis and rulings of tribunals of other regional organizations, like the Economic Community of Western African States, ECOWAS, whose revised Treaty of 1993 affirmed and declared member states' adherence to the recognition, promotion, and protection of human and people's rights in accordance with the provision of the African Charter. Later on, in 2005, a supplementary protocol was adopted, which allowed individuals to come before the court if they had a case of human rights violation against any member state. Critical analysis underlined overlaps, need of more clarity and precision. That was, of course, true, but at the same time, it represented a genuine effort towards compliance. Dialogues may also make room to cross-fertilization, as in the case of the jurisprudence of international criminal tribunals, which, by the way, have made important contributions in the field of women's rights. In this context, in its Furunzia judgment, the ICTY took advantage of the cases dealt with by the Inter-American Commission on Human Rights dealing with rape in armed conflict, notably the case of Raquel Martí de Mejía and of the statements and comments by the UN Special Rapporteur on Torture. In 1998, the ICTR, the International Criminal Tribunal on Rwanda, on its side, authored the first judgment convicting a person for genocide as described in the 1948 Convention in the case of Akayesu. One of its main contributions to women's rights was to consider rape as a physical invasion of a sexual nature committed on a person under circumstances which are coercive. In the distance between the consent approach and the coercive circumstances lies the difference between sexual rights and rape. Other fruitful dialogues are equally significant. Among the new features of the time, for instance, are the dialogues between foreign corporations and national governments in the context of investment arbitration. Starting early in the 70s, the Washington Convention has been the source for litigation of 706 cases as of the end of last year. Foreign investment arbitration involves actors like corporations, generally big, with private business interests, and states. It reaches national public policies as well as workers' and consumers' rights. The universe of areas covered is important, and the consequences of the rulings are impressive. As I stated before, however, none of the dialogues and even of the accomplishments was exempted from tensions. In the Americas, the way back to democratic rule in the 80s, after gross and systematic violation of human rights, gave room to transitional justice mechanisms and to the strengthening of the democratic system. International law enforced in the 80s had no specific rule applicable to transitions. Democracy, truth, and justice were the three values that almost every new democracy had to face and to strengthen. In real life, the tools of transitional justice were framed in Latin America, when Argentina started to pave its way back to democracy. Three decisions, whose political scope was huge, showed the path that the government of President Raúl Alfonsín would follow. The annulment of the self-amnesty declared by the military, the establishment of an inquiry commission, and the prosecution of the men responsible for the illegal acts. Shortly after that, the Inter-American System on Human Rights would establish the obligation to prosecute regarding the most serious crimes as a regional rule in its reports dealing with the measures adopted in Argentina and Uruguay to restrict jurisdiction over the crimes of the past. The political will to stop immunity took shape in the Rome Statute, which provides for the complementary jurisdiction of the International Criminal Court when the most serious crimes of international concern are committed and states do not exercise their jurisdiction over them. When the statute became binding for nearly 2/3 of the states of the international community, the regional rule requiring states to prosecute became universal. Transitional justice helped many of our societies to reach a better political health to face the future. There have been inquiry commissions in the 4 corners of the world, not all of them with the same scope or follow-up means, but still all have performed those essential functions of coming to terms with the past, and the great majority have been good in truth-telling. All these transitional processes have faced tensions, but in all of them, the acknowledgement of the truth and the exercise of jurisdiction according to legal standards contributed to a healthier democracy. In fact, international law became concerned about democracy almost at the turn of the century, when Haitian President Aristide was put out of government, and Peruvian President Fujimori performed a self-coup. The Organization of American States reacting by introducing a provision in its charter through the Protocol of Washington. On 9/11/2001 in Lima, the Inter-American Democratic Charter was adopted, embodying the right to democracy of the peoples of the Americas and their government's obligation to promote and defend it. From a formal point of view, the Inter-American Democratic Charter is not a binding instrument. However, it has been frequently enforced. It was first invoked in 2002 at the request of President Fox of Mexico when a coup d'etat in Venezuela tried to ouster Hugo Chavez from government. Actually, the situation evolved so quickly that Mr. Chavez was reinstated before the institutional meeting could take place. It was also enforced regarding situations in Bolivia, Ecuador, Peru, Nicaragua, Honduras. In almost all of them, the tension was growing as the mechanism increased its pressure over the de facto government. Recently, its enforcement in the case of Venezuela, whose electoral process was qualified as fraudulent by international observers, failed. In any case, the game is now in the international arena, and the situation is rapidly evolving. Democracy today means many things, including a form of government with its rules, principles, and guarantees, especially the protection of human rights. But it also encompasses a set of values and promises that citizens deem important and in which they put their hopes and expectations. Transparent, decent, and inclusive societies. In the same vein, responsibility to protect, R2P, was born as a last instance remedy in cases which traditionally had been qualified as calling for a humanitarian intervention by the most powerful states. In fact, it is a product of the human rights community. The three pillars of R2P are the responsibility of states to protect their populations, which is the necessary inference from sovereignty. But as it happens in The Little Prince, l'essentiel est invisible aux yeux. What is essential is invisible to the eye, and so it has to be reminded. The responsibility of the international community to assist states in protecting their population before the conflict escalates. And third, a commitment by the given state to take appropriate action. So far, R2P has been implemented a few times. However, it failed in Syria. When states with vested interest play hide and seek, the problem does not lie on the rules, but on compliance. When states comply with the rules, some accomplishments are able to enlarge the field. In the early 90s, former Yugoslavia smashed into pieces and ethnic cleansing was practiced. The Security Council, acting under Chapter 7 of the UN Charter, decided to establish an international criminal tribunal to pass judgment on the violations of international humanitarian law occurred in the territory of former Yugoslavia since 1st January 1993. A similar tribunal was set up at the request of Rwanda in 1994. Finally, in 1998, the Rome Statute for the International Criminal Court was adopted. It entered into force 4 years later, and now it has 123 states parties. This institutional structure was meant to stop impunity regarding the most serious crimes of international concern, to give redress to the victims, to enforce the never again, to help in building up a more decent world. The international criminal law has become a ghost in the closet of many authoritarian rulers. Those who never thought of being ever accountable for their crimes, like Hissène Habré in Chad or Charles Taylor in Liberia, finally got a judgment convicting them for war crimes and crimes against humanity. The establishment of international criminal tribunals was possible because, among other things, the international community decided that there are some rules which are more important than others. In 1998, when Mr. Akayesu was convicted for genocide by the ICTR, the International Court of Justice had already established the erga omnes status of the prohibition of genocide in the preliminary objections in the case concerning the application of the Convention Against Genocide in 1996. The ICJ came back to that in the judgment on jurisdiction and admissibility in the case of the armed activities, Congo versus Rwanda, 2006, and in the case of the application of the Convention Against Genocide, Bosnia-Herzegovina versus Serbia and Montenegro in 2007, where the court qualified the rule as jus cogens. This is about considering and balancing, and I quote, the propagation of human rights logic in the body of international law rules. In sum, in the ratification, in one way or another, that there are public international law rules more important than others, and that this level of importance, established in view of social priority, translates into law a regulatory supremacy or higher status, unquote, as taught by Pierre-Marie Dupuy in his general course at the Hague Academy. In fact, human rights are one of the main accomplishments of this legal and political order. They have provoked a genuine Copernican change in the way individuals are perceived and treated all over the world, even in those places where law seems to be absent. However, human rights did not enjoy full citizenship in international law for a while. As opposed to the law of the sea or the law of treaties or diplomatic immunities, human rights law was only dealt with by human rights actors. In the last 20 years, human rights have come into the International Court of Justice jurisprudence. In 2004, when it rendered its advisory opinion on the legal consequences of the construction of a wall in Palestinian occupied territory, the court relied on the reports of the special procedures to conclude that the construction of the wall and its associated regime impede the inhabitants of the occupied Palestinian territory the exercise of specific rights protected by the two 1966 international covenants on human rights and on the Convention on the Rights of the Child. In 2005, for the first time, the ICJ held a state accountable for its internationally wrongful acts in the area of human rights when it decided that the Republic of Uganda, by the conduct of its armed forces, had violated its obligations under international human rights law and international humanitarian law, meaning by that the Fourth Geneva Convention and the First Additional Protocol on International Humanitarian Law, the International Covenant on Civil and Political Rights, the Convention on the Right of the Child and the Additional Protocol on the Prohibition of the Use of Children in Armed Conflict, and the African Charter on Humans and People's Rights. At this time, there are 9 core human rights treaties, and 7 of them are binding for almost 82% of the state's communities. There are also customary rules and soft law. There is no single state without at least a treaty obligation in the field of human rights. Of course, not all states have accepted the supervisory mechanism's competence, but it should be reminded that that has no effect on the compatibility of particular acts with their international law provisions. On top of that, the regional systems are especially effective in Europe, Africa, and America. We are waiting for Asia to have a good human rights system. In a context in which, and I quote, there is a sustainable culture of human rights, unquote, as Michael Riesman said here in 2013, my view is that the great importance of international human rights law lies in its capacity to become a set of criteria for the interpretation of legal rules. As such, it serves both as a branch of international law and as a cross-cutting set of hermeneutic tools. Last, but in no way least, let me stress that the prohibition of the use of force by states in their international relations, except through self-defense, is one of the two greatest revolutionary changes in this legal and political order. This importance was confirmed by the ICJ, which frequently enforced the rule and its exception in the last decades. Starting with the well-known case of the military and paramilitary activities in and against Nicaragua in 1986, the court distinguished the most grave forms of the use of force, those constituting an armed attack, from other less grave forms, and used such a distinction to raise the threshold of the resort to force, giving right to self-defense. The ICJ argued against the unilateral use of force by states in international relations in different cases involving big and small states in different regions, as it did in the case of the oil platforms or the armed activities Congo versus Uganda. Its jurisprudence was also telling when the court was not in a position to decide because it lacked jurisdiction, as it happened regarding the failed rescue operation in the case of the US diplomatic and consular staff in Tehran, or the cases brought by Yugoslavia against the NATO states on the legality of the use of force. Let me close with a couple of comments on my perception about international law as an instrument. All these developments require cooperation, a truly UN policy which translates into an international binding system of rules adopted and enforced by international organizations in almost every international law field. Look at the need to leave no one behind in areas like environment. All these achievements could not have been reached without international law, without this common language, which started as a state-oriented enterprise and which developed in the last years, protecting people from war, respecting individuals, giving room to self-determination, acknowledging indigenous peoples, expressing concern about trade and investment, caring for global commons. There are still gaps, of course, lacunae. We are all aware of that. Had the man in my first example, Fulgencio Batista, or other former presidents lived today, this is the international law they would have had to face in Cuba or elsewhere. They would face now an international legal system which, overcoming turbulent tensions and thanks to its main accomplishments, has become today an efficient instrument in spite of its failures. If these achievements are acknowledged, in the future, we might expect an even stronger international law in which new cross-fertilizations and more dialogue will pave the way to a more communicated world and to a better life for all of us. We have to commit to work for that. Many thanks for your attention.
That was wonderful. Can I do a question?
Yes, of course.
I'm going to exercise the prerogative of the president of the society to ask Monica Pinto a question. Imagine that I am the U.S. Secretary of State.
I have to come again to this country, and I need a visa for that.
Be creative.
You have to know that.
I look at Venezuela.
Mm-hmm.
I see a deep country in distress, human rights violations running rampant, civil liberties denied, economic rights so bad, people fleeing the country. I want to do something about it. And I think that I can deploy a military force that will go to Venezuela. And we don't know, but I think I have a strategy that would fairly quickly topple the government and allow for a different government to be placed in power. I might go to the Security Council to get authorization, but I confide in you, I think it's unlikely. And I've heard about this doctrine of responsibility to protect. And I ask you, can we take that doctrine seriously in some way and use it for such a military action? What would you say?
Well, putting aside my issues on the visa, my first answer will be an answer of principle. I don't agree with the use of force, and I don't think Venezuelans will feel happy with their President Maduro being ousted because of the use of force by the big brother of the Americas. I think that we are in this situation. We are in the present situation in Venezuela because of our own success, because of what international law has achieved during all these years. I think that on the one side, there is a huge network of corruption in the country, which prevents Maduro from giving place to another one, because they are so close that if the first falls, all the other will fall after him. But at the same time, I'm persuaded that Mr. Maduro is aware that if ever he quits the country, he will have to face an international criminal tribunal, and that he will be convicted for genocide, for crimes against humanity, for depriving his population, a population of a country which, at the time we had dictatorship in Argentina, was our refuge country, a country which had oil and resources, for depriving the population of that country of the most basic need, the possibility to eat, to have food. And so I think that perhaps what we can imagine from international leaders is just to find the ways and means to produce a sort of trade-off. Just get out of there, allow the people to express itself, and to find the ways in order to put in government some decent people that will have to build the country again. It's from scratch. They will have to build the country again. And I think that in so doing, the armed forces in the country have a role to play. I have no doubt that the armed forces want to remain there. They want to be in government next time, and the following one, and the following one. But for so doing, they have to pay attention to the people. They are giving their back to the people. So the only way in which that could have some decent way of solution is the armed forces, which are the most powerful in the country right now, which I think are very much divided, just become aware that their first function is to protect the people and to back the people in that.
Please join me in thanking Monica Pinto for a fabulous address. Thank you so much. Well done. We're almost finished with the assembly, but I have three quick announcements. First, the 2019 mid-year meeting of the Society will be held on November 7th to 9th at our academic partner, Brooklyn Law School. There's a little cheering section for Brooklyn Law School. Professors Julian Arado, Kristen Barnes, and Rebecca Hamilton will serve as the co-chairs of the Research Forum, and Ina Popova of ASIL law firm Leadership Circle partner Debevoise and Plimpton will serve as chair of the Practitioners Forum. The call for abstracts for the 2019 Research Forum is currently open, and I encourage any of you with unpublished papers or ideas for papers on any topic of international law to consider submitting an abstract. This includes submissions from students and new professionals, one of whom will receive the second annual David D. Caron Prize. The Society will also be awarding a limited number of David D. Caron Fellowships to attend the forum. Second, I'm also pleased to announce that we have launched the request for proposals to host the 2020 ASIL mid-year meeting. We plan way in advance. And if your institution is interested in submitting a proposal to host the 2020 Research Forum, you'll find that call for proposals on the ASIL website. Third, 18 months ago, we launched our Signature Topics Initiative, an innovative effort to engage the Society's diverse constituencies in sustained collaborative activities on cross-cutting international legal issues. At the 2018 annual meeting 1 year ago, after inviting proposals from our membership, we announced the first two topics. One on atrocity prevention, the role of international law and justice, and the second on beyond national jurisdiction, human activities in the oceans, polar regions, and outer space. Both signature topics have generated tremendous energy and enthusiasm, and are yielding concrete results, including two special programs taking place at this very annual meeting. Given that success, the Executive Council has decided to extend both of those topics for one additional year and to call for a third signature topic that will commence this spring. So please stay tuned for us putting out that call for a new topic. As we adjourn, I'd like to invite you to join us for our gala reception. It's going to be held actually across the way in the International Terrace West on this terrace level. It will not be upstairs and outside as indicated in your program due to the rather chilly temperature out there. We do hope that we'll warm up tomorrow such that our gala reception tomorrow night will be outside. So please join us starting at 7:15 across the way, or just immediately after this event across the way. At 7:15, we have a further event. It's the President's Reception. We love parties. This is going to be sponsored by my colleagues at George Washington University Law School. That will be in the Kalorama room, which is upstairs. So gala reception first across the way, 7:15 upstairs for the President's Reception. It's a dessert reception in case that interests you. Ladies and gentlemen, the assembly is adjourned. Thank you so much for coming and have a pleasant evening.